Welcome to This Explainer. Today, we're diving into the fascinating and honestly kind of hidden plumbing of the criminal justice system. Think of it like a massive funnel. Every single alleged crime, every police report, every private complaint, it all gets poured right into the top. And sitting at the very bottom of that funnel, that's a judge, specifically a magistrate. They are literally the ultimate gatekeeper here. Their whole job is to filter out the baseless claims, the false accusations, and the weak evidence before a trial even gets a chance to start. So we're going to map out the exact procedural journey a case file takes, from the very first moment it hits the court's radar, all the way to a potential trial.
To keep things super clear, we've broken this journey down into 5 main steps. First, we'll figure out what cognizance actually is. Second, we'll compare police reports against private complaints. Third, we'll check out the magistrate's immediate next steps. Fourth, we hit the crucial fork in the road, dismissal or issuing process. And finally, step 5, committal to the sessions court.
All right, let's jump right into part 1. What exactly is cognizance? This is the very first step in our journey.
So, cognizance. It's a pretty heavy piece of legal jargon, officially governed by Section 210 of the BNSS. But let's translate that into plain English. It's basically the precise moment a judge formally acknowledges a situation and says, okay, I see this crime and I am officially taking judicial notice of it. Think of it as the starting pistol for the whole legal proceeding. Without taking cognizance, the court system hasn't actually formally recognized that there's an offense that needs to be dealt with. Now, how does the case actually get there? Well, there are basically 3 distinct doors a case can walk through to officially land on the magistrate's desk. First, someone can file a direct complaint laying out the facts of the offense. Door number 2, the police finish their investigation and hand over a formal police report or charge sheet. And the third door, the magistrate can actually act on information received from any person or even rely on their own personal knowledge that a crime went down. It's set up this way so that crimes can't just easily slip through the cracks, no matter who happens to be reporting them. Moving on to step 2, police reports versus complaints. These are 2 very different tracks.
You know, the path a case takes to enter the system really changes the rules of the game. Let's look at a police report case first. This starts with an FIR, so the police are investigating out in the real world before the court even gets involved. Because the cops have already done all that legwork, the magistrate can take cognizance directly on that report, and nobody needs to be examined on oath right away. But flip that and look at a complaint case. Here, a private citizen is marching straight up to the magistrate. Since there's usually no prior police investigation, the law demands that the complainant and their witnesses be examined on oath right out of the gate. The system is basically saying, look, if the police haven't verified your story yet, you're going to have to swear to it right now.
Just a quick side note on system efficiency here before we move forward. Under Section 212 of the BNSS, there's a process called the making over of cases. Picture a chief judicial magistrate taking cognizance at literally hundreds of cases. To keep the gears turning, they actually have the power to transfer, or make over, these cases to competent subordinate magistrates. It's essentially a smart workload distribution tool to make sure cases aren't just piling up on a single desk.
Okay, step 3. Let's look at the magistrate's next steps and how they go about gathering the evidence. So, the case is officially in the pipeline. Once the magistrate grabs the reins, there are strict, absolutely crucial procedural duties they have to follow to ensure fairness. First up, like we just talked about for complaint cases, they've got to examine the complainant and witnesses on oath under Section 223. Second, the accused actually gets a right to be heard before cognizance is even taken. And third, this is huge for a fair trial. Under Section 230, the magistrate has to supply copies of the police reports, FIRs, and witness statements to the accused within 14 days. And what's really cool is how the law is adapting to the digital age here. If those records are incredibly huge, handing over the documents can legally be done electronically.
But here is where things get incredibly fascinating. What if the police finish their investigation, hand the report over to the judge, and say, hey, there's no case here, let's close it. But the victim completely disagrees and vehemently protests. Do the police get the final say? The answer is a massive no. And we have a landmark Supreme Court precedent to thank for that, H.S. Baines versus UT of Chandigarh. This ruling makes it crystal clear that the magistrate is an independent gatekeeper who is totally unbound by whatever conclusions the police draw. The magistrate actually has 3 options here. Sure, they can accept the police closure report and shut it down. But option 2, they can look at the evidence, completely disagree with the cops, take cognizance anyway, and issue process against the accused. Or option 3, they can treat the victim's protest petition as a brand new formal complaint and kick off the complaint procedure. The bottom line, the police investigate, but the magistrate decides. That brings us to Section 4, dismissal or issuing process. This is the crucial fork in the road. We have officially reached the ultimate filter point, where the magistrate decides if a case lives or dies. But before picking a path, the magistrate can actually hit the brakes. Under Section 225 of the BNSS, they can order the postponement of issue of process. Honestly, just think of this as the justice system's pause button. The magistrate pauses everything to run a quick inquiry or order further investigation, just to double-check the facts before dragging someone into court. And get this, hitting that pause button is absolutely mandatory if the accused lives outside the magistrate's jurisdiction. It's a built-in shield to protect people from being harassed by fake claims filed in faraway courts.
So let's head down the first path of that fork. Say the magistrate uses the pause button, reviews all the evidence, and realizes, you know what, this claim is completely baseless. There are no sufficient grounds to proceed. Well, that triggers Section 226. The complaint is dismissed outright. The filter catches the bad claim, the case dies right then and there, and the accused is saved from a really grueling trial. The magistrate just has to briefly record their reasons for tossing it out.
Okay, but what if there are sufficient grounds? That takes us down path number 2, Section 227, the issue of process. The case survives and moves forward. The magistrate officially summons the accused to court, using either a summons or a warrant depending on how severe the charge is. Though it's worth mentioning that the system isn't always super rigid. Under Section 228, the magistrate might actually let the accused appear through their lawyer rather than showing up in person, at least for the initial stages.
Finally, we arrive at Step 5, committal to the Sessions Court. We're moving up the ladder.
Now, you might be wondering, what happens if the crime is something really severe, like a murder? That kind of case is just too major for a standard magistrate to handle, and a higher court, like a Sessions Court, can't just pull a case out of thin air. It literally has to be sent up to them. This handoff is called the committal of a case, governed by Section 232. To put it simply, committal is just the magistrate passing the entire case file, all the evidence, and the accused person straight up the judicial ladder to that higher court of session. Why? Because the law explicitly says only that higher court has the authority to try an offense of that magnitude.
And the system definitely does not let these serious cases just sit around gathering dust. There is a very strict procedural clock ticking here. Starting from day 0, which is the exact date the magistrate takes cognizance, they have exactly 90 days to wrap up the paperwork and commit the case upward. They can stretch that deadline to 180 days, but only if they write out specific reasons justifying the delay. No slacking allowed.
Before we wrap up this explainer, I want you to hear this incredibly powerful quote. The Supreme Court of India stated, "The court takes cognizance of the offense, not merely the offenders." Just let that sink in for a second. That one single sentence really defines how true justice is supposed to operate. Here's why that quote is so crucial. It's known as the Kishan Singh precedent. Imagine a case gets committed up to the Sessions Court. The judge is looking over all the evidence and suddenly realizes, wait a minute, there are other people involved in this crime that the police completely left off the report. Well, because of this precedent, the higher court isn't restricted by the police's arrest list. Because the court took cognizance of the offense itself, not just the people listed on the paper, they have the power to independently summon those missing suspects to face trial. It's a brilliant plot twist that guarantees no one escapes justice just because they managed to avoid the initial police paperwork.